Alex here with part 76 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So I don't have a whole lot of memory or recollection with regards to my mindset at this point in the litigation. One thing that I do recall is being annoyed that the government and my ex was resisting this because, in my opinion, it was obviously wrong. And ultimately, it would be the opinion of the Supreme Court that it was wrong as well. But I eventually drew on my experiences like these to create videos like They Will Never Say Good Things and Win at All Costs. And those two mentalities are ultimately what will keep somebody fighting a losing fight, even if it's obviously wrong. There's just other ways to win a case, even if you are not on the right side of the law. And part of it is psyching your opponent out, and the other part is just fatiguing your opponent into just giving up. So again, mainly annoyed, and the only reason I say that is because I also felt kind of buoyed by the Supreme Court of Nevada's response to the petition for mandamus. They were ordering the government to respond. They were ordering my ex to respond. And so, I mean, I didn't have as much experience then as I have now to really know just how rare it is for a petition for writ of mandamus to be considered by the Supreme Court. But I did have an inkling that my particular approach, which was to bypass the district courts, I did have an inkling that that was definitely something that was rarely considered. So at this point in time, the Supreme Court was ordering responses, despite the fact that I bypassed the lower court, that I filed this petition for writ of mandamus directly in the Supreme Court, and so that gave me kind of a boost as far as my mindset at the time. I was optimistic, let's put it that way. So at this point, we're just going to have to go straight into what the Secretary of State has filed. Here we have the Secretary of State's answer to my petition for writ of mandamus. So they lead off in the first paragraph by identifying themselves and indicating that the government is being represented by the Attorney General Kathrine Cortez Masto, and more specifically Solicitor General Wayne Howle. Even though Kathrine Cortez Masto is the actual Attorney General, at least at the time, she isn't right now, it's still very, very common for the Attorney General themselves to not actually appear or file anything in these cases. They have one of their deputies or one of their solicitors do that for them instead, just because there's way too many cases and it's just not possible for the actual Attorney General to be involved in every single case. So I believe in this case we've had 2 people involved so far. Well, generally, with regards to this issue, we've had 2 people involved so far. The other one, his name was like Nguyen, something like that. But this guy, Solicitor General Wayne Howle, is going to be on for the most part until the very end, at which point one of the chief deputy attorney generals is going to be on instead. Anyway, moving on, they are indicating that they are filing this answer in response to my petition for writ of mandamus. Statement of the case. So, let's see here. They are characterizing this as a quest again to learn the residential address at which my ex and son live. The respondent supplied a confidential address to my ex and son in 2009 pursuant to the provisions of the law establishing Nevada's confidential address program. The petitioner seeks disclosure. Issues. First, we have the sole issue, which is whether this law authorizes the government to issue a fictitious address to the applicant based on mere existence of a protective order. And it's pretty wordy, but I think he's basically getting it right. I'm arguing that the government needs to consider the substance of the protective order prior to giving a fictitious address. And the petitioner may certainly present whatever issues he will, but by presenting them in the form of a petition for a writ, the issues necessarily include whether there exists a in law, a mandatory duty for the Secretary of State to disclose the address. Okay, so I mean, he's basically saying what I'm saying, which is whether or not the law requires the Secretary of State to do some investigatory work, to exercise some discretion in issuing a fictitious address. And the Supreme Court of Nevada is not going to go with this theory. They're going to go with a constitutional theory. And we'll get into that when we actually get to their order, but just giving everybody a heads up. At this point in time, they're going to go with the constitutional theory, and they're going to create a different procedure by which to challenge the Secretary of State's issuance. So in a sense, they don't agree with either of us as to whether or not the Secretary of State has a burden to do this. They are going to say that there is a burden, but they're going to put the burden on the court instead. Statement of the facts. So he is first asserting that we lived together in 2008. Our relationship ended in 2008. Police were called to the residence. Then he states the police responded to a call. The call concerned a suicidal subject, which is attached as Exhibit 1. This is probably just a police report. Then he asserts that the police responded to a call made by her complaining of a disturbance, and that's Exhibit 2, presumably the other police report. It's interesting that they actually bring these police reports up because as far as I know, my ex didn't give them copies of these police reports at all. So what he's doing is he's probably relying on the evidence that I submitted to him. The report indicates there were allegations of pushing, etc., etc. On August 25th, I instituted custody proceedings in the district court. On September 8th, a TRO was issued against me in a separate case. This is already covered in my docket series. On May 26th, child custody order was entered. We shared joint legal and joint physical custody. On September 10th, I applied to the Secretary of State for a confidential, my ex applied to the Secretary of State for a confidential address. The application was granted. On October 13th, I filed a petition for judicial review, which the court denied. On June 3rd, I filed a notice of appeal, which the Supreme Court affirmed. And then on October 12th, in the Supreme Court case, I appealed a district ordinance. Okay, so I don't know why he's bringing this up. This isn't relevant to this at all. Sometimes I think that attorneys think that they can win a case by showing how many times you've lost in the past. A judge needs to decide a case on the merits of the case. They don't get to go, well, since you lost the last 6 cases, I'm going to make sure you lose this one too. They actually have to look at the issues in the case before them. But a lot of attorneys do this. And I also have mentioned before to my viewers that this often can backfire on them because a judge will see that an issue keeps coming up, and sometimes rather than saying, okay, this guy's getting denied all the time, so I'm going to deny his motion, sometimes they'll say, okay, well, whatever I've been doing in the past isn't working, so I need to take a closer look at this. So this isn't necessarily going to cause somebody to lose their case, but this is a common tactic used by attorneys. And then we have the petition for writ in this docket. So he's just basically telling them that I filed this writ petition. Summary of the argument. He's going into the writ of mandamus and how it can be used, and one of those ways is to compel the performance of an act which the law requires or prohibits. I guess you could say it that way too. Here, there is no right for me to have the residential address of my ex. What? Okay, so this is patently wrong. So under the 14th Amendment, there is a right, and the Supreme Court of Nevada will recognize that in their opinion. But this is a right that's been recognized long before this petition was entered. So it's disturbing that this attorney is trying to say that a parent doesn't have the right to know where their child resides. But that's the argument that he's going to make, I guess. Next we have, I guess, a more detailed argument. So much of the following argument comes from the state's response in 56169, which is true. He is, for the most part, regurgitating the arguments that he put forth in the other case. And most of those arguments are relevant to this case. Not all of them, but most of them. Upon research, little more has been written or decided on the subject. Legislative history of the law is not particularly revelatory. So what he's saying is that the legislative history on the law doesn't really help explain what we should do in this case. Which I guess is true. They didn't really debate it much. They just kind of created the confidential address program without thinking it through. I think somebody from the legislature should have said, hold on a second, guys. This makes sense when you're dealing with two people who broke up that don't have kids. But what are we going to do when they broke up and they do have kids? Nobody thought of something so obvious as that. They just passed a law without considering that, and they should have really thought about that, because that happens more often than not. It's not just that people break up. A lot of times they have kids and they break up. It's not that rare for that to occur, but they didn't think of that for whatever reason. The exhibits attached to this brief contain the temporary restraining order that served as the basis for the confidential address. TRO was all that was legally required under the law, and this is the argument that I figured they would make. An applicant for an address is only required to provide specific evidence showing, and then there's that law, subsection 4 right here of NRS 271.462 that lists a protective order specifically in that area of what they want to, what they want to count as evidence in this particular context. And I've said this before to my viewers over and over again, context matters. And in the context of the confidential address program, this order of protection is evidence because a law says so. It's not evidence because our own mind as an individual says so. It's evidence because the law declared it as such. The legislature establishes Nevada's confidential address program in 1997 as an important tool to fight against DV. The quantum of evidence necessary to justify it is the legislature's choice. So he's basically saying that even though I'm saying this really isn't evidence at all, the legislature said so, so therefore it is, which is true most of the time. But here we have a conflict with the Constitution of the United States, which is where I'm able to sort of wedge in the case that I'm bringing to the Supreme Court. Now, I didn't think that was going to be my primary argument, but that's the one that the Supreme Court of Nevada went with later on. Just as in Nevada, Washington's program, so he's comparing it to Washington. He's basically saying, since our program isn't that different than in other states, this isn't really any big deal. So in Washington, we have a similar program. He's mentioning that different states have different requirements. Moving on. At the other end of the spectrum, requiring a high showing are Indiana, Rhode Island. So Indiana and Rhode Island apparently have more stringent requirements for you to get a fictitious address. So I think he's trying to, this is a smart argument. The problem is the Constitution is going to crash right into it. But if you take the Constitution out, under this standard, just without people's fundamental rights being implicated, the government would probably get away with it. And you have to think about it this way. If we didn't have a kid, would this really be a big deal? Do I really need to know where my ex resides if we don't have a kid together? The answer is no, I don't. And should she really have to show a tremendous amount of evidence to be allowed to hide from somebody she purports to be a DV abuser? No, not really, because if you guys are broken up and you don't really have any constitutional right as to why I need to know where they live, then they really shouldn't need to show a whole lot in the first place. But here we go, dealing with a specific case involving a child and, of course, the 14th Amendment of the Constitution. So moving on. Additional safeguards for the veracity of an applicant's information, including, in addition to relying on restraining orders as prima facie evidence, and he goes into, again, other states. So here he's going into California. The reason I'm kind of glazing over these arguments is because the Supreme Court doesn't really go with any of this in the end anyway. The Supreme Court takes the constitutional route, for the most part, to deal with this problem. Otherwise, I would spend a lot more time on these arguments. But what he is doing is comparing Nevada's statute to all these other states, and he's trying to bring up to the Supreme Court the fact that there is a sort of wide variation as to how the states deal with the confidential address programs, and you have one scale where very little needs to be shown, and you have one scale with a whole lot that needs to be shown to get a confidential address program, and he's trying to show them sort of where Nevada fits in on that scale. And again, all of that is actually a very sound way to argue a case like this, with the Constitution aside. Here we have another assertion that the Secretary should not rely on a temporary restraining order. He's saying it's meritless because the legislature expressly identified a restraining order as one of the forms of satisfactory evidence. And he's saying that that's the law. And that's true. The Supreme Court of Nevada does agree with this position. The Supreme Court of Nevada says this is the law, therefore the Secretary of State cannot do anything more than issue an address when provided with this evidence. But what I don't think he anticipated was where the Constitution would come into play. So the Supreme Court of Nevada is going to state, you're right, this is the law. The law says that this is how it works. However, the law, valid as it may be, conflicts with the 14th Amendment of the Constitution. Therefore, and then they basically just blow a hole through the law. Moving on. The next is here the assertion that my only real argument is, as a father of a child, that I have the right to know where my child resides. So this is my real argument, though his next sentence here he says I do not, and then this is where he gets it flat wrong. I can't believe that he would be so bold as to say that a parent does not have a right to know where their child resides. To me, that's really going too far, and I think if more people knew that could be politically damaging for this person if he decides to run for an election or something. But to take the position that a parent of a child doesn't have a right to know where their child resides is beyond disturbing. I don't think anyone in this country would agree with that. Most people think, I want to know where my kid is. Most people don't think I don't have a right to know where my kid is. So he probably could have said this better. What he probably should have said is, you don't have a right to know where your child resides if you are a DV abuser. He shouldn't just say that no parent anywhere in the state, no matter how good they are, has no right to know where their child resides. That is a scary position to take for an attorney. Hopefully he doesn't run for anything in the future. Going on, it says, authorities he offers for this position do not in fact stand for it. No such authority exists. Champagne v. Welfare and Santosky v. Kramer, as cited by me, generally addresses the right to make decisions concerning the care, custody, and control of one's children, but do not specify anything resembling the right to know where a child resides. So he might be right about this. These cases might specifically on their faces not mention anything about having a right to know where your child resides. But the Supreme Court of Nevada traces these cases deeper down to a foundation where they hold that we actually do have a right to know where our child resides. And again, this isn't new. This is something that the Supreme Court has held for a long time. So it's not like I'm suddenly creating this right to know where your child resides. That's always been there. Moving on. Falcone does not complain that he cannot see his child or that he is deprived of a relationship with the child. His only complaint is the bare inability to know where his child resides. Again, disturbing position to take. This is not a legally recognized interest for which a writ of any kind should issue to enforce. Again, a disturbing statement that a parent doesn't have a legally recognized interest in knowing where their child resides. Finally, a fictitious address by law may only be effective for 4 years and will be canceled thereafter, absent proof of imminent danger. No way would my ex have let this be canceled. This law here allows you to apply for an extension, and there's nothing in there that says you have to show anything new has occurred. You can just apply for an extension and get one. So if the Supreme Court of Nevada did not intervene and get involved in this specific case, my ex would have extended this over and over again until our son was 18. This is not a 99% chance probability. This is 100%. This is absolutely what she would have done. Without question, no doubt whatsoever, she would have continued to extend the fictitious address. So this is a pointless argument. Conclusion. The petition asks the court to compel the secretary to release the residential address of persons who were properly given a fictitious address. However, I have not identified any mandatory duty for the secretary to surrender the information. So I have identified a mandatory duty, but it's not the statutes that I brought to the Supreme Court's attention. It's the constitutional principles. Those constitutional principles are what create the mandatory duty for the secretary to surrender the information. But it has to be done through court action. And we're going to get into that again when we actually see the opinion of the Supreme Court. They're going to explain why I'm right. Moving on to the index of exhibits. And this is, let's see here, referencing exhibits that were provided. Oh, so they're actually all included here. So I don't know why he's calling this an index of exhibits. You know what I think he did? I think he used my index. Well, I didn't even call it that. I just call it a list of exhibits. And I didn't do this correctly. And so it seems like he sort of copied me. But by copying me, he ended up doing it incorrectly as well. This should be an appendix. It should be called an appendix. And inside of the appendix is an index of exhibits. And inside, I don't even know if they call it the index of exhibits. I think they just call it the index. And then inside of the index, you'll have sort of a table of contents with page numbers as to where you can find each specific item. And what it is it's the record. It's the record that the Supreme Court uses to make their decision. So it seems to me like he kind of copied my approach, which was wrong in the first place. And he did it wrong by copying the person who did it wrong. Again, we're going to talk about this more when I get into one of my actual proper appendices. Later on in this My Docket series, you're going to see me file an appendix the correct way. And when we get to that appendix, we're going to go over it more in detail. But there's no point in talking about all of the things that are wrong with this, because later on in the My Docket series, you're going to get to one of my filings that's correctly done. Might not even need to look at any of these because I think I went over all of these already in the My Docket series. So these 2 police reports I've already gone over within the first probably 5 or 6 videos of the My Docket series, so I'm going to skip over them. Temporary order of protection, again, already went over this in the My Docket series. Order after hearing, already went over this. Confidential address program application. I don't think I've gone over this. And then we've got the order denying judicial review filed 5/18. Actually, I did go over this application because it came up in the other appeal. So I've actually gone over all 6 of these exhibits already in the My Docket series, so I'm not going to go over them again. This is what I typically do in the series when I come across documents that I've already gone over. If you'd like to, you can always go down into the description below, click on the link, download this document, and review it for yourself. And if you have any questions, you can go ahead and put them down in the comments below, and I will address your question at that point in time. But I won't go over documents that I've already gone over in the series. If you've been watching in order, you would have already seen my analysis on all of these filings. So let's continue on to the affidavit of service. This is indicating that it looks like an employee of the Attorney General's office, correct? Here she is asserting that she's an employee, and it's indicating that she, in response to the Supreme Court's order, served a copy of the documents listed in Exhibit A on my ex. So the Supreme Court of Nevada ordered the Attorney General to serve these documents upon my ex, and this is an affidavit from somebody who works with the Attorney General indicating that she has indeed served these documents upon my ex as to, as how they were ordered to by the Supreme Court of Nevada. And apparently they were mailed. Here we go. Yes, they were mailed on both myself and my ex, or at least this specific affidavit was. A copy of the affidavit of service was served. Oh, so she's indicating that this affidavit of service was served upon us, and she's also indicating earlier on in this document that the remainder of those documents were served specifically on my ex. And here we have an index of, this is the exhibit she was referring to. I don't know why it was put in as a separate filing, but for whatever reason it was. And she's indicating that these are the documents that she served upon my ex, which are basically the filings in this Supreme Court case. Everything that was filed in this case has been served upon my ex. We've already gone over all of these filings, so I'm not going to go over them again. Next, we have the affidavit of service. And this is, what is this here? It looks like it's the same, different address. Okay, so this is the same exact thing that we already went over, only they served it on my ex's fictitious address. This 303 Roop Street address is a fake address. Same thing. So it's the exact same thing, only it's being served on my, this is so confusing. They probably just messed something up and sent it to the wrong address. I'm not going to pull it apart or nitpick through it because all we know is my ex was eventually served. Whether it was the P.O. box here, the fake address in Carson City, or some other address. They filed the exact same affidavit of service trying to indicate that they served the papers on another address as well. Here we have the same exact index as before. This is just referring to the documents that were served at the different address. Proof of service of documents to my ex per court order. I don't know why didn't they just indicate this all? Oh, so these are the actual, I guess the proof, you could say. It's the proof. This is one of those little cards indicating that it was served on my ex, I guess through certified mail. Yep, certified mail. And this is apparently some kind of proof of receipt. So they must have gotten their certified receipt, whatever, the thing that indicates that the person certifies having received the documents. And it looks like another one with certificate of service. So this is just the government indicating that this specific proof was sent to me at my address at the time. This is an ancient history address. Here we have the notice of intent to participate provided by my ex's attorney. And my ex's attorney has basically reviewed all of the documents provided to them by the government. They have reviewed the Supreme Court's order offering them an opportunity to participate in the case if they would like to. And my ex's attorney has stated in this notice that she does intend to participate in this Supreme Court case. And here is a certificate of service by mail indicating that this notice was provided to both the government and myself. And then we have a Supreme Court order in response. And this is a Supreme Court responding to my ex's notice of her intent to participate. So let's see what they're saying here. It's a petition for writ of mandamus. That's the type of case that we're in right now against the Secretary of State of Nevada. And in accordance with the Supreme Court's order regarding my ex as a third-party recipient of the fictitious address here, they're recognizing that she's filed a notice of her intent to participate in this case. Therefore, she shall be added as a real party in interest to this original writ proceeding. And the clerk of this court is directed to modify the caption of this matter to conform with the caption in this order. Now, my ex has an opportunity within 30 days to file an answer to my petition, and I also will have the right to, if I choose, file a reply to her answer. And this is the way the caption should have appeared in the first place. This is how I should have just done this straight from the get-go. I caused an unnecessary delay in my case by not doing it this way. But here's what I was talking about right from the beginning of this video. I am the petitioner, the government is the respondent, and my ex listed clearly as a real party in interest. Going into the aftermath, I didn't file any of these documents, so I incurred $0 in costs. The government filed 7 of these documents, and all of them were free filings, so the government incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government would have incurred some substantial attorney fees at this point. The Secretary of State's answer to the petition, it would probably have taken several hours, maybe 3 or 4, but because most of the arguments were recycled based on what they filed in the previous appeal and the previous district court case, I think it would be safe to say 1 hour. It still feels a little low, but yeah, most of the time probably went into the appendix, or what they call the index of exhibits. So I guess we can err on the side of 1 hour at this point. There would have been some research, but all of that would have been done in the previous cases anyway. So 1 hour is fine for that petition. The index of exhibits is at least another hour. I have worked on appendices before. They take forever. It's easy to underestimate how long it'll take to put together an appendix. So an hour, I think, is fair, even though it wasn't that large. It could have been much larger. So at this point, we're at 2 hours. Then we have the 2 affidavits of service that they put together. We'll put each of those at 5 minutes. So we're at 2 hours and 10 minutes so far. We have both of those indices, which were probably 20 minutes each, which is going to take us up to another hour. So we're up to a total of 3 hours so far for both of those affidavits and the indices. Then we have the proof of service that was filed. That's negligible. I'm not even going to count any time for that. Or I guess you could lump that in with the notice of intent to participate that they would have to review and the order regarding participation. If you take all those last 3 documents, you could probably roll them together into an additional half hour at most, only because they're going to have to change their system to include my ex's information now that she's going to become a party to the case and all of that. So we have 3 hours and 30 minutes, which at the rate of $250 an hour is going to come to $750 plus $125, which would be $875 in attorney fees for the government. Then we have my ex, who is just now making an appearance in the case. She did file the notice of intent to participate, but that's a free filing, so she incurred $0 in costs. Her attorney would have prepared that notice for her, and I think at this point in time, preparation of the notice would have maybe been 5 minutes, but she would have had to at least consult with my ex over it, maybe an email or 2, maybe a phone call. So I think 15 minutes for the notice of intent to participate sounds good. Then she would have had to review all of those filings. There's a lot of review for my ex's attorney to have to do, but I suspect that she would have probably glazed over most of it. I think most of her preparation is going to go into the filing of her answer to my petition. So I think a sort of cursory review of all of the documents that have been filed this far in this case, of which there are many, let's just lump all of that into 45 minutes, combined with the 15 minutes that it took her to put together the notice of intent to participate. That should come to, at the rate of $250 an hour, $250 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post it down in the comments below, and I will see you guys next time.